Very good evening, everyone. Good evening, students. Okay. So, first of all, I welcome each one of you to my class on the topic Complaint Proceedings from CrPC 1973. So, let's begin with this class. So, first of all, I welcome each one of you. So, let's start with my brief introduction. And my name is Sandeep Khatri. You can see my areas of specialization: the constitutional law, criminal law, commercial law, family law, jurisprudence, and law of torts. Students, I have shared the link of my profile of Unacademy, so make sure you follow that to get all the updates about my special classes and my plus courses. Here is the link of my Telegram channel where you can connect with me and ask your questions in relation to your judiciary preparation. At last, I have mentioned my code Khatri10, which you can use to get free access of all the special classes available on Unacademy app. So this was about me. Now I request everyone, please be attentive, and this is going to be an interactive session. So the moment you feel you are not clear with anything, feel free to ask your questions in the comments and I'll answer accordingly. So let's start this topic with some important MCQ. These are some repeated MCQs from the complaint proceedings of CrPC. And if you have any question in relation to this topic, you may ask in the comments. Very good evening, Man Singh. Okay. So very first question, examination of complainant under section 200 is done by whom? Yes. Choose the most appropriate answer. The first option is about investigating officer. Second option is about officer in charge of police station. And the third option is of magistrate. And the last option is both A and B. There's a spelling mistake of magistrate. So just ignore that. Yes, please. So section 200 is basically about examination of complainant. This section comes into the picture because there are three ways how you can make criminal law into motion. The very first one is the most basic one, that is FIR. The second one is this complaint proceedings, and the third one is by giving information or suo motu. So we are discussing about the second option, which is basically examination of complaint. So the moment a person, the complainant comes with a complaint in front of the magistrate, then the magistrate will start the examination of that complainant under section 200. So the answer is the magistrate. Okay, there is no role of investigating officer or officer in charge of police station. The role of officer in charge of police station comes into the picture at the time when someone go to the police station to lodge the FIR. Okay, so moving to the next question. So the correct answer here is the C option, that is magistrate. Mansingh Mausami, correct answer, that is C. A magistrate taking cognizance of an offence on complaint shall examine upon oath. So he will examine which of the following? The option number A, the complainant; B, the witnesses; C, the victim; D, A and B. Okay. Now, first, do understand the question, students, here. The question is about the now the examination will be taken place of whom? The complainant, the witness, victim, or both A and B. Okay. So the correct answer here is first the examination is going to take place of complainant. Okay. Whosoever has gone with the complaint. Victim can also be the complainant, but as far as this particular question is concerned, the answer is going to be the complainant and the witnesses if present. So both will be examined. Okay, there will be no role of victim. So the correct answer here is D, both A and B. Now I have one additional question in reference to this, and that is, what about the accused? Can the magistrate, anyone please do answer in the comments, can the magistrate examine the accused under section 200? Yes, please do answer in the comments. Can the magistrate examine the accused under section 200? And the correct answer is, students, no. Okay, when it comes to accused, there is nothing in relation to accused as far as your section 200 is concerned. Why? Because it is all about complainant, the witnesses if any, and the magistrate. That's it. Okay, now one more question. When we talk about this magistrate, okay, what magistrate we are talking about? Judicial magistrate first class, judicial magistrate second class, chief judicial magistrate? Which magistrate we are talking about who is taking examination under section 200? So the answer to that question is the magistrate who has ability to take the cognizance in that matter will go with the examination. Okay, so basically we are talking about judicial magistrate first class, and second class if that is empowered by chief judicial magistrate. Next question. When the magistrate need not to examine the complainant and the witnesses under section 200. Okay, first one to answer correctly, Monica. C. Yes, C is the correct answer, students. Because as per to the question is when the magistrate need not to examine the complainant and the witnesses under section 100, 200. So when you will read section 200, there are two exceptions which are mentioned in 200 only. If a public servant acting or purporting to act in the discharge of his official duties or a court has made the complaint. So that is the first exception. And the second one is if the magistrate makes over the case for inquiry or trial to another magistrate under section 192. So the correct answer here is both A and B. Next one. The term complaint has been defined under section. Which section defined the term complaint? Monica, first one to answer correctly, Sheikh Sana, 2D. Yes, students, section 2D defines the term complaint. Okay, so 2D is the correct answer. Okay, now complaint should be in oral form or in written form. Answer in the comments. So these are basically the essentials of the complaint. Yes, complaint should be in oral form or written form. Mosumi, okay, Sheikh Sana, first one to answer correctly. followed by Mosmi and Monica. The correct answer, students, it can be oral as well, or it can be in written form as well. Now, coming to one more question, the last question, that is, can police officer file a complaint to the magistrate? Answer in the comments. Can police officer file a complaint under section 200? Okay, Monica, first one to answer, no. What about others? Okay, Sheikh Sana, yes, he will then be treated as complainant. Yes, can file. Okay. Now let me give you the answer. Just listen carefully. Students, when it comes to the concept of complaint, that has been defined under section 2D. Okay. And police officer, when he is going to file the police report under section 173, that will not be treated as complaint. So the answer is, there is one general rule. The general rule suggests that the police officer cannot file a complaint. Okay, that is the general rule, but it has one exception as well. Okay, it has one exception as well that has been mentioned under section 2D explanation part. Now, what is the exception? The exception is, if a police officer investigate in a case which is of non-cognizable offense, and that is without warrant. So basically, the issue was that the police officer got some information, and that information was of the cognizable offense, and he starts the investigation, but later on he found out that the offense that has taken place is non-cognizable. Now he has done the investigation without warrant. Now this particular situation will be forwarded to magistrate, and then the complainant will be police officer, and the magistrate will decide whether there were such circumstances, or it was some intentional or a genuine mistake from the police officer end. The reason is, when it comes to cognizable offense, the police officer has all the powers to do the investigation. But when it comes to non-cognizable offenses, okay, the police officer first needs to take the order from the magistrate. So that is why we will say that in general rule, no, police officer cannot, but in the exceptional circumstances, the answer is yes. I hope it is clear. And if you have any doubt, you may ask. If not, I'll move on to the next question. Yes, Monica, police report shall not be treated as a complaint. Okay. Chalo. Next question. Complaint made by the complainant under section 200 to the magistrate shall be reduced to writing and signed by. See, as far as the essential of section 2D is concerned, the complaint may be made, that is, maybe in oral as well or in written form as well. But once the complaint has been made, that shall be reduced by to writing and signed by. So whosoever is going to sign that, choose the most appropriate option. First one to answer correctly, Monica, and D is the correct answer. So there will be signature of magistrate, the complainant, and obviously the witnesses, if any. Anurag and Mosami, correct answer. Next one. If the complaint is made to a magistrate who is not competent to take the cognizance of an offense and the complaint is not in writing, he shall choose the most appropriate option, and do write the section number as well if you can recall the exact section number for the reasoning of your answer. Okay, Man Singh has answered D. Monica C. Anurag 201 CrPC, answer is C. Okay. Man Singh, please do correct yourself. Monica, Anurag, and Sheikh Sana, top 3 students to answer correctly. See, there are two things which you need to notice. The very first one is that the complaint is not in writing. And just because if the complaint is not in writing, then you will direct the complainant to the proper court. Okay? And what if, and this is under section 201, and what if the complaint was in the writing? That is basically your next question. The same question, the same options, the only difference is now we are talking about the complaint is in writing. Then the magistrate shall choose the most appropriate option. The answer is again from your 201 only. Monica, first one to answer correctly, and that is right. If it is in the written form, then the magistrate will return it for presentation to the proper court with an endorsement to that effect. So this is the difference. This is the difference basically when the complaint is in writing and when it is not. The complaint proceedings are under section. Complaint proceedings are under section. Correct answer. Ritu, please do a refresh. We are on question number 8 as of now. Monica B. Anurag A. Okay. So students, when it comes to complaint, this particular term that has been defined in section 2D, and when we are about complaint proceedings, they are basically from section 200 to 203. When it comes to 204, we are basically on the issue of process. So A cannot be the correct answer. When it comes to section 199, this is basically your cognizance, okay, which has been in the exceptional cognizance in the defamation cases, okay. So 199 cannot be the correct answer. Similarly, 200 to 205, again wrong, because from 204 it is about issue of process. So the correct answer is section 200 till 203. Which of the following statement is incorrect? Ritu and Anurag, please do correct your answer. Complaint proceeding is from section 200 till 203. If you can answer this question correctly, I can assure you you are done with the complaint proceedings. Yes, if you can answer this correctly, you are done with the concept of complaint proceedings from CrPC. Okay. Only student to answer this correctly, Mosumi. Yes, Mosumi. Completely correct answer. See, students, the question was which of the following statement is incorrect? Not correct. Incorrect. So now coming to the first one, examination of complaint. Complainant is under section 200. This is the correct statement. So this cannot be the answer. Postponement of issue of process under section 202. This is again correct. Yes. Magistrate shall discharge the complaint under section 203. This is incorrect, which means this is the correct answer. Why? Because there's a difference between discharge and dismissal. And when it comes to section 203, we are basically talking about the concept of dismissal only and not about the discharge. Discharge is that stage that comes after once the charges has been framed. Okay? So C is the correct answer. Ritu, please do correct your answer. C is the incorrect statement. Okay? चलिए जी. Next one. After dismissal of a complaint under section 203, a fresh similar complaint on the same facts. Choose the most appropriate option. Sheikh Sana, first one to answer. C. Monica, followed by C. Yes, correct answer, students. The answer is that a fresh similar complaint is not banned and will be entertained. Sheikh Sana and Monica, if you can please tell me the reasoning behind that. Why C is the correct answer? If you can tell me the reasoning. Why after the dismissal of the complaint that will be entertained. Okay, now let me tell you the reason, students. See, uh, a complaint under section 203 is a fresh complaint is not banned. Okay, there is no specific section in the CrPC that basically banned the fresh complaint. So that is why it is not banned. It will not be considered as banned and it will be entertained. Now let me give you a basic conclusion of this whole chapter in a graphical sense. So the story starts with the complainant, okay? And the complainant went to magistrate and then the magistrate will start the examination. And the objective of this examination is to figure this out, that whether the complainant is telling the truth or not. So once the magistrate has done the examination, there can be three circumstances. So the very first one can be that the magistrate is sure after the examination that the complainant is telling the truth. In that circumstances, if the magistrate is satisfied with the examination, then he will issue the process, which means basically after section 200, the magistrate will go to directly to 204, that is issue of process. But now coming to the next circumstances. What if the magistrate is not satisfied? Then the magistrate will go under section 203 and he will dismiss the complaint. Now what if the magistrate is not sure about 204 or 203? Then the magistrate will choose the third option, that is basically section 202, which is about postponement of issue of process. And in this, the magistrate may take also the help of the police officer, and he may also command him to do the investigation. And after this 202, once the magistrate is convinced, he will either choose 204 or will go to 203. So this is the conclusion of this whole chapter, that is of examination of, that is of complaint proceedings. Now anything if you are not clear with, you may ask in the comments. Monica, answer to your question, dismissal before trial or conclusion. See, there are two stages, okay? Once the charges are done, after the charges are done, okay, there is concept of discharge. And once there are no charges, and before that the magistrate is convinced that there is no such case, then it is a case of dismissal. So this is the major difference. See, once now look at this. The complainant went to magistrate. Magistrate starts the examination of section 200. Now, if after this examination the magistrate is convinced that the complainant is lying, now what will the magistrate will do? The magistrate will simply dismiss the case. So there is no process of, there is no process of charge between examination and 203. So that is why it is the case of dismissal. And yes, once the case has been dismissed, it may be the complainant may come up with a fresh complaint. There is no bar on that. There is no particular section. Okay. And once the charges has been framed, and after that the prosecution failed to convince the magistrate that they do have the sufficient evidences, then the magistrate will discharge the case. And at the end, there is going to be conviction or acquittal. I hope it's clear now. Let's bring this to the conclusion. So anything which you are not clear with, you may ask your questions. So students, this is the link of my profile of Unacademy, and this is my Telegram channel, and this is my code Khatri10. Let's crack PCS J with Unacademy. This is a rapid revision for UP and Chhattisgarh Judiciary, started from December 20. This is the Prarambh batch for 18-month Judiciary Foundation batch 2022 for all state judiciary exams, starting from December 27. This is the Sankalp UP PCS J prelims batch from December 17th. This is the revamped test series for judiciary learners for this December. This is the Unacademy subscription prices as of now. This is the magazine Articulate, which is coming soon, a monthly current affair magazine from Unacademy. These are the YouTube channels of Unacademy. And these are the Telegram channels of Unacademy. And that's it from my end. See you in my next class. Till then, yes, it's time to say peace.